Good morning, friends. So today we are going to discuss about the limitation period for issuing a notice under section. So today for issuing a notice under section 148. So under section 148, a notice is issued for reassessment under section 147. So for any reassessment of an income, a notice has to be issued under section 148. And for issuance of a notice under section 148, the time limit or the limitation period is prescribed in section 149. Now, today what I want to discuss is that section 149 was substantially amended with effect from 1st April 2021. Now, prior to the amendment in section 149, there was a time limit which was quite different from the time limit which is there in the present law. That is the time limit for the issuance of notice under 148 is different from what it was there till 1/4/2021. So the issue which I wish to discuss is that whether suppose any notice is issued after 1/4/2021 and the assessment year is prior to 1/4/2021, then whether the time limit which is prescribed in the law as it exists today after the amendment with effect from 1/4/2021, whether this new time limit will be applicable for any assessment year prior to 1/4/2021, that is assessment year up to 2020-21, or the time limit for issue of notice as it existed till 1/4/2021, that old time limit will apply. So that is the short issue which I wish to discuss today. But before I do that, let us discuss as to what was the time limit in the erstwhile 149, that is the time limit up to 1/4/2021, and what is the time limit which is as on date. Up to 1/4/2021, the time limit was up to 4 years unless the case falls under exception provided under clause B and clause C. So ordinarily the assessment notice could have been issued till 4 years, but under clause B of 149 subsection 1, the time limit was 6 years from the end of the relevant assessment year. And for applicability of 6 years time limit, the income escape should have been more than 1 lakh rupees. And there is a time limit up to 16 years also, but that is applicable in very exceptional cases where the property is situated outside India. So if there is an income in relation to which any escapement is there and that is sought to be assets, then income should be in relation to an asset, including financial interest in any entity which is located outside India. So the income should arise out of an asset which is situated outside India, only then the time limit of 16 years applied. So ordinarily, for normal SSEs, the time limit was 4 years if the escaped income was less than 1 lakh rupees. And if the escaped income was more than 1 lakh rupees, then the time limit was 6 years. Now, with effect from 1/4/2021, this time limit was amended. Now, this time limit is 3 years if the escaped income is less than 50 lakh rupees and it can go up to 10 years if the escaped income exceeds 50 lakh rupees. So now not only the time limit has been changed, but the limit of the escaped income for applicability of the lower period and the extended period has also been enhanced. Prior to 1/4/2021, the escaped income limit was 1 year. For applicability of the lower period of the reopening of the assessment, that was 4 years. And if it exceeded 1 lakh, then the time limit went up to 6 years. But in the new one, section 149, for the issue of notice under section 148, the time limit is 3 years if the escaped income is less than 50 lakh rupees, and it is 10 years if the escaped income escaped income is more than 50 lakh. And now it not only talks about the escaped income, but it says that the income chargeable to tax, which can be represented in the form of an asset or expenditure in relation to a transaction or relation to an event or an occasion, or any entry or entries in the books of account, which is escaped income. So even a book entry for which a proper explanation cannot be given by the SAC, and if that exceeds 50 lakh rupees, then that also gets covered with the purview of section 149 notice. Now, the issue which I want to discuss is whether the new time limit will be applicable or the old time limit will be applicable. Now, to get an answer for that, we must look at first proviso to section 149. So I'll just share that 149 with you. For you to appreciate as to what exactly I wish to discuss. Just give me a moment. I'm just sharing that file relating to that section 149 first proviso. I just want to show you what it says. It says that no notice under section 148 can be issued. So as you can see, the first proviso says that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning or before 1st of April 2021, if a notice under section 148 or 153A or 153C could not have been issued at that time on account of being beyond the time limit specified under proviso of clause B of subsection 1 of this section, or section 153A or 153C, as the case may be, as they stood immediately before the commencement of Finance Act 2021. So what it means is that if no notice under section 148 could have been issued at any point of time in case of a relevant assessment year, which is beginning or before 1/4/2021, then a notice under section 148 could not have been issued under the new act. So even after the amendment, so even after the amendment, So the amended section says that the term which is used in first proviso is that at any time. So at any time means the date of the issue of the notice, and it also says that as it stood prior to the amendment in the Finance Act 2021. So the two words here are crucial. No notice under section 148 could have been issued at any time. So this is the most important phrase here, that any time. That means if the assessment year is prior to 1/4/2021 and the notice could not have been issued at any time on account of the expiry of the time limit as it was provided prior to the amendment, then the notice could not be issued now also. So effectively, the first proviso means that if a time limit of 6 years has expired and the escaped income is more than 1 lakh rupees, then the notice cannot be issued in terms of the amended provision. Now it may so happen in some cases, because now for escaped income below 50 lakh, the reduced time limit is 3 years. So in some cases, it may be possible that the amended section is beneficial to the SAC, but by and large, in most of the cases, since in the amended provision, the time limit is 10 years, whereas in the earlier law, the maximum time limit was only 6 years. So this pre-amended section 149 will be beneficial. And if any notice is issued under 149, then the SAC should immediately object, because I have seen that most of the notices which are being issued under the new provision, they are being issued by presuming that the amended section 149 applies. So income tax department is presuming that amended section 149 applies, the old 149 does not apply. So that is a presumption. So if it is beneficial to the SAC, for example, it is issued by presuming that the time limit is 3 years and your escaped income is less than 50 lakh rupees, then obviously the SAC should not raise an objection to the time limit. But suppose the escaped income is more than 50 lakh rupees and the department is issuing notice by taking recourse to the amended section 149, then the SEC should immediately raise the objection saying that your notice is beyond jurisdiction, because once the time limit expires, then the assessing officer has no jurisdiction over the SAC to issue a notice. The time limitation is an issue of jurisdiction, and therefore immediate objection should be raised and requesting the officer to withdraw the notice forthwith. If it does not withdraw and proceeds to adjudicate the matter, then the SAC can approach the High Court by way of writ jurisdiction under section 226 of the Constitution of India to get the notice quashed. And in this regard, there is a judgment of Honorable Bombay High Court in the case of writ petition number 450 of 2023, the judgment dated 28th February 2024, where the Honorable Bombay High Court has categorically decided that for assessment year which is expiring on 1/4/2021, section 149 as it existed prior to the amendment will apply. Otherwise, the first proviso to section 149 will become redundant in OTOs. And therefore, if the assessment year is, for example, say 2014-15, then the sixth year expires on 1/4/2021. And if suppose a notice is issued today by taking recourse to the amended 149, then the SSE should immediately raise an objection. And if the assessing officer still proceeds with the assessment procedure, then they should approach to the High Court to get the notice quashed. In this regard, there is a recent judgment of the Honorable Calcutta High Court also, where the issue is not finally decided, but nevertheless, the Honorable Calcutta High Court has stayed the proceeding by relying upon the amended section 149 in the case of SCI India Limited in writ petition number 10387 of 2024. So, friends, with this, I conclude my today's session. Thank you very much.